The delisting of firms from the daily official list of any exchange simply represents the depletion of the total market capitalization of the affected exchange. Welcome to another edition of the Nigerian Investor. Last week, we looked about the proposed SEC amendment on audit committee membership. Today, we want to look at the NSE draft rule on delisting from the daily official list. The Nigerian Stock Exchange, in its effort to complement the Securities and Exchange Commission on market development and regulations, has exposed its draft rule regarding the listing of listed issuers from the exchange for comments. The draft rule, which set out provisions on the requirement as well as instances where delisting can be done, and the process is set out to address three key issues, and they are voluntary delisting by issuers, regulatory delisting, and relisting of an issuer security on the exchange. Voluntary delisting: an issuer that intends to delist his shares from the daily official list of the exchange shall convene a meeting of its board of directors, at which the board shall consider a recommendation to the shareholders of the issuer that the issuer should be voluntarily delisted, and a resolution in that regard is passed, and b. an annual general meeting AGM or extraordinary general meeting EGM, at which the board's recommendation will be considered by the shareholders for approval, and a resolution in that regard is passed. The issuer shall notify the exchange of his board's recommendation to delist and shall submit a copy of the board resolution in that regard, and the issuer's request for approval to publish the notice of AGM/EGM, at which the shareholders will consider the board's recommendation to voluntarily delist the issuer in at least 2 national dailies and at least 21 days before the AGM/EGM, and a copy of the draft notice of the AGM/EGM. After receiving the exchange approval, the issuer shall convene an AGM/EGM, during which a resolution for voluntary delisting the issuer will be proposed and passed if agreeable to the shareholders. The exchange shall be invited to and be presented at the AGM/EGM. A resolution to voluntarily delist an issuer shall be validly passed if supported by at least 75% of the members present and voting during the AGM/EGM in person or by proxy. The issuer's board of directors shall appoint professional advisors who will provide all relevant professional support as well as obtain all relevant approval with respect to the delisting. The issuer shall apply for a court-ordered meeting of the shareholders to consider and, if thought fit, approve where required any scheme and other relevant matters. After receiving the court order, the issuer shall convene the court-ordered meeting of the shareholders, and the exchange shall be invited to and be represented at the meeting. After holding the court-ordered meeting, the issuer shall submit his resolution passed at the meeting to the court for sanction. The dealing member shall submit to the exchange an application on behalf of the issuer to delist its shares from the daily official list of the exchange, and the application shall be submitted with a delisting fee as determined from time to time by the exchange. The application shall be considered by the quotation committee of the National Council of the Exchange to ensure, among other matters, that the interests of minority shareholders are sufficiently protected. The application to delist will only be granted if approval by the QCN. The issuer shall set aside funds sufficient to purchase the interests of all shareholders who express their dissent to the resolution to delist the issuer, and the funds shall be domiciled with a registrar or a custodian duly registered by and in good standing with the Securities and Exchange Commission. The share price at which the issuer purchases the certain shareholders' interest shall not be less than the highest price at which the issuer traded in the 6 months immediately preceding the date on which the notice of the AGM/EGM at which resolution to delist the issuer was issued. Upon receipt of court sanction, a certified true copy shall be filed with the Corporate Affairs Commission. The entire listed shares of the issuer shall be placed on full suspension upon receipt of a certified true copy of the court sanction, evidencing the filing of the sanction with the CAC. The registrar or custodian shall open and publish a register of dissenting shareholders, which shall be kept open for at least 3 years. The list of dissenting shareholders shall be published on the company's website for the same duration and submitted to the exchange within 3 months of the shareholders' expression of their dissent. The entire listed shares of the company shall be delisted from the daily official list upon receipt of evidence from the registrar or custodian that the interests of all dissenting shareholders have been purchased by the issuer. Except a period of 3 years has elapsed since the initial listing of its shares, the exchange shall not consider an issuer's application for delisting of its shares. On regulatory delisting, delisting at the exchange instance is the ultimate sanction that can be imposed on an issuer for persistent non-compliance with the listing rules of the exchange or for failing to meet the financial requirement of listing on the exchange. An issuer that persistently violates the rules of the exchange or is unable to meet its obligation or commit an infraction that attracts a penalty of delisting shall be notified of an impending enforcement action by the exchange and shall be given 4 weeks to regularize his listing status. Upon determination by the exchange that the issuer has failed to regularize his position, the exchange will serve the affected issuer with a notice of delisting. The notice of delisting will be published in any number of national dailies as may be determined by the exchange, or in any media outlet as may from time to time be determined by the exchange. The notice of delisting will provide the issuer with a 3-month notice period during which the issuer is expected to regularize his listing status. The exchange will publish a final 1-month notice of delisting at the expiration of the 3-month notice. At the expiration of the final 1-month notice, a non-compliant issuer shall be delisted from the exchange daily official list. The exchange will notify the market of the delisting of the issuer and will publish same in any number of national daily newspaper as may be determined by the exchange and or in any media as may from time to time be determined by it. The exchange shall notify the Securities and Exchange Commission within 48 hours of delisting the issuer. On relisting, the issuer of a delisted security can seek to have the security relisted on the exchange after 3 years on the date of its delisting. If the proposed rule goes through, we hope it will help reduce the rate of delisting on the Nigerian bourse as more firms seem to be applying for voluntary delisting in recent times. The following are upcoming AGMs in the market: Access Bank PLC on the 7th of May 2015, Fidelity Bank PLC on the 7th of May 2015, IBM Holdings on the 21st of May 2015, Transcorp PLC on the 8th of May 2015, and USC Properties on the 1st of September 2015. On corporate actions, the following companies has recommended dividend. ETI recommended 1 for 15 bonus shares with closure date set for 25th of June 2015. FBN Holdings recommend 10 kobo and 1 for 10 bonus with closure date set for 1st of June 2015. And USC Properties recommended 50 kobo with closure date set for 31st of August 2015. CBN to review the Nigerian check standard. The Central Bank of Nigeria, in collaboration with the Bankers Committee, introduced a codified check standard and a check printers accreditation scheme in 2006 to facilitate an efficient clearing system in Nigeria, with the core objectives of promoting efficiency in the clearing system through reduced reject rate, facilitating imaging technology and archiving, reducing check fraud by specifying the design and security features on the instrument. The standard has been in operation for about 9 years and has contributed in no small measure to the enhancement of the national payment system. However, in order to ensure that the standard continues to be relevant in meeting its objective, the CBN is requesting for proposal from suitably qualified Nigerian and foreign organizations to review the Nigerian check standard and Nigerian check printer association scheme document. That's all we have for you on this edition of the Nigerian Investor.